time for that. Let's go around to the floor. Yeah, well, are we taking?
Yes.
Okay. Well,
Good afternoon. Thank you for coming. My name is Mary Gardner, and I'm the assessor.
Hello, I'm Eileen Pardillo, purchasing agent. Welcome.
Good evening. Greg Hanover, Director of Public Works.
Bruce Jones, Town Councilor.
John Burt, Town Manager.
Hi, John Reiner, Director of Planning and Development Services.
Hi there, Melissa McGuire, Tax Collector. Hello, I'm Anisha Green, Director of HR and Risk Management.
Pleased to meet you all. Are our microphones stay live?
Yes. So you have up to 30 minutes for a presentation. By no means do you have to take that long. And once that's completed, we'll go around the room with some questions.
By no means will by no
minutes total.
means will we take up 30 minutes. I promise you. Only because we can do this right now. We can say our firm's been around for 47 years. So, what. The firm's service to a town like Groton and towns in general has really been a more recent phenomenon in the sense that I, Rich, Matt, Duncan Forsythe, who's also in our package, who does labor work. He's in South Carolina right now and couldn't join us. And Jen Penavillano, who's another labor attorney, is also had child care issues, and she could have joined virtually, but we said we'd rather just be doing it in person. But several of us have been involved in our own community government as volunteers, and through the years have represented towns periodically, but we got together and decided what we can offer something special because Halloran and Sage, I just told you how long the firm's been around, but it has pretty much all facets in terms of very talented lawyers in complex areas of law. But because the law has gotten so complex, towns who used to, small towns especially, but we do work for cities and towns all across the state, the law got more complicated. And a typical model was someone involved in the community, a lawyer in the community, was selected to be the town attorney, and then, as it turns out, so many things that they have to deal with were things that they couldn't handle. So we would have the ability on the one hand to be able to provide all of that under one roof, but also have essentially a small firm within the larger firm where we create relationships, attorneys that are in our municipal group, the lead, we each take leads in different towns. I was selected to serve and would be, we think, a good fit as the point person for you folks. But we could do it at a rate that was effective for towns. So although our private rates are much, much higher, we could do that. And we began, to establish our municipal practice. It's the largest municipal practice in Connecticut. And I actually have never done this with a prop, but just to give you a sense of some of the breadth of the work that we do. The orange are the towns that we represent in Connecticut right now in one capacity or another. But particularly, if you're talking about general counsel towns, we go so far as representing Sherman out in the New York border, a whole host of towns in the central part of the state, east of Hartford, northwest of Hartford, and a whole slew of them in eastern Connecticut, including several right in the Groton area, Montville, Preston, Griswold. Now we go up to Voluntown, Sterling as special counsel, general counsel to Killingly, Putnam, Thompson. So we really expand our work all around the state of Connecticut, but we establish a relationship with the towns. And if you check in on our references, you'll find that one of our hallmarks is responsiveness. If we hear, especially as more towns have recognized that they needed to go with larger firms sometimes so that they could have everything under one roof. What they've lost is some responsiveness, and or you're dealing with a small firm where somebody's doing just has too much on their plate and doesn't have the ability to do that. So we pride ourselves in being able to not only, have our cell phones, we get calls in the evening or in the middle of a meeting, you didn't expect an issue would come up. We get those calls, and you'll have more than one of us with that call and information, and you'll get to know more than one of us. And when something happens, if you can't reach one of us on vacation or is at a meeting and can't pick up the phone, you have somebody else that you can call. So we recognize that people, so many people are doing it, especially the elected folks. There's no big training when you come into that job, and that there's, you have the benefit of a town manager form of a government, and it's a more sophisticated town. You certainly have some benefits, but it is amazing how often things will come across your desk that you haven't seen before. And that's one other thing that we have and then I think we'll turn it over to these folks, and I'll tell you just a little bit more about what I do particularly. But the other thing that we have that's a benefit, as a very large municipal group, we have the benefit of seeing not everything, but darn near it. So because of the number of towns and the municipal work to do, if Rich gets the call or I get the call or Matt gets the call, we probably we might have the answer right there. You don't need a research. We don't need an associate to go spend a bunch of hours. We probably have a good idea right off the bat. If we don't, one other resource that we use among ourselves is we have a municipal, our own little listserv inside the office, and it's remarkable about, hey, we've got this contract that just came across regarding this unusual solar project that's different than anything I've seen. Has anybody else, seen that before? And it's remarkable. Somebody says, yeah, and we get to take advantage of some work that already happened that we've done for another client. So that results in some real cost competitiveness, not just on our rates, but on the fact that we can give you often speedy answers from the benefit of the amount of towns that we do the work for. So I can just say I've been practicing for just over 30 years. The majority of my work deals with land use, general municipal, this kind of stuff, and environmental work. One of the persons that's on our list, Ann Catino, she does almost exclusively environmental work. So mine's a little more on the land use side, but that's the majority of stuff. Although I've seen lots of things, I do litigation and transaction side. So usually the litigation relates to land disputes and land use matters. But that's the majority of the kind of work I've done. I joined Halloran in 2001. Was in a firm in New Britain called Eisenberg, Anderson, Michalak and Lynch for 10 years prior to that. The school when I was at UConn Law School. So that's a bit about myself and the firm, and these guys share some about themselves as well.
Go ahead, Rich. My name is Rich Roberts. I'm a partner in the Municipal Practice Group. I've also been practicing for over 30 years. Ken's aged better than I have. I don't do litigation, but I do the transactional stuff. I do more of the municipal governance kinds of things, ordinances, charters, contracts, real estate transactions, those kinds of things. I usually end up getting the random questions about things like minority representation and how you do the ARPA funding and, Public Act 490 and just kind of the bizarro municipal world of, day-to-day things. Just to kind of amplify on what Ken said, I mean, we kind of made a conscious decision that we wanted to represent municipalities. It's not something that we chose to do because we ran out of other things to do that paid more. It's something that we felt strongly about, and as he mentioned, all of us are involved in our home communities, so we understand what it's like on the other side of the table to have angry people staring at you at 9 o'clock at night, and we can appreciate it. And I think as a result of that, rather than giving you long, detailed legal answers with case citations in it, when what you really need is common sense guidance on, how to get out of a situation that you're in, how to get from point A to point B. Sometimes it's not a direct route. Sometimes you kind of have to back up and go, maybe in a different direction, but, our objective is to make sure that you get where you want to be, you accomplish what you want to accomplish with the least exposure and heartburn possible.
I'm Matt Willis, and I've had over 30 years of experience. I've probably aged the worst, but that's okay. I do land use, I do general municipal law, I do tax lien foreclosures, tax sales, assessment appeals, and transactional work. So over the years, I've handled all these matters, and at a certain point, several years ago, when we were had my own firm in Glastonbury, Branson Willis, and we joined Howler and Sage specifically because we wanted to have the ability to tell clients, yes, we have someone that does labor law. Yes, we have someone that can handle your AIA contract or whatever it might be, so that, as Ken was saying, it's a little firm that does municipal work, but then it's a big firm that does specialty, and it's really worked out well. So, I think that's really why we're here today, is to help you guys out.
What's her specialty, just so I know, what's her focus?
Who is that?
Your colleague that did not, wasn't able to join.
Jen Pettivillano or Duncan Forsyth would have joined us because they bring the labor element to it. And we also have, Kevin Green is also back in our firm, but the persons who would have joined us in person would have either been Duncan or Jen.
Okay, great. We're going to have a series of questions now, just so you kind of know where we're at on timeline. We have 22 questions, which is a lot. If we don't get to them all, that's fine, but just so you kind of gauge your...
Are they true, false, or?
Yeah.
Multiple choice, or hope they're not essay, that's all.
But, Arnisha, just so we're not jumping back and forth, do you want to go first? So our format's going to be up to two questions the first, and then we'll go back around.
So we aim to be responsible towards the budget and the best use of time and resources. When negotiating a collective bargaining agreement, or CBA, after how many sessions and at what point might you suggest bringing in a mediator? What about moving to arbitration?
All right, Arnisha, is your mic on?
I did that so everybody would. Take two. Okay. Okay. So we aim to be responsible towards the budget and the best use of time and resources. When negotiating a collective bargaining agreement, or CBA, after how many sessions and at what point might you suggest bringing in a mediator? And then what about moving to arbitration?
All right. We just passed the Super Bowl, so this is one instance. I'll use a football analogy, and it's to some degree I'm punting the answer to this one because that's Duncan. He's handling a series of collective bargaining agreements for towns this fall. I know because he's represented our towns for decades doing this. He approaches it in the same style that Rich just described, which was a practical one. I've not heard him say that there's a real formula for how he's done that. I think that he gauges the particular situation. Sometimes there's a contentious history. There's one that's pretty clear that a third party might be necessary sooner rather than later, and others where he's able to develop a good rapport and is able to avoid having to bring one. But his key would be to communicate with you, assess the situation, and kind of lay out those options. That's something that we do in general, is try to give you what options are available. We might have one we feel strongly about, and you might not like that one. But I know that's the way he's approached it. But it's not entirely fair for me to be to answer it because I'm not the guy that's been on, and none of us are the guys really on the ground doing that. But I really do think that's his approach. Do you think that's a fair summary?
Yeah.
So I have some in the same genre, so I'll give it and see where we go with it. Please describe the preferred labor negotiation style and strategy.
I think it's similar to the last answer, a partial punt, except I have knowledge, having worked with Duncan. He's done it for a long time, and he brings a sincerity to it. He would be more likely than Jen, although both of them would have an opportunity. I think, given his experience, it's try to bring a relationship of trust with the other side, to get to the heart of what the issues are, have the dialogue, communicate with you well, and try to be collaborative with a solution. Sometimes you got to take the gloves off and duke it out, but I think by and large it's just try to assess and establish a level of trust with the other side, because each side has goals, and the only time you get an agreement is when you find the right places to give and the right places to get.
Yeah, I mean, I'm not sure whether this is part of what you were getting at, but I know that his approach is to basically sound the town out about, do you want somebody by your side in the room from day one, or do you think you have a good enough relationship that we can kind of be a sounding board or a resource after the meetings, during breaks and so forth, or do you want to go in lawyered up? And I know that it varies depending on which union it is, who the negotiator on the other side is, and also on kind of the dynamic between the town and the particular bargaining unit. Is it one where people are going to be looking to reinvent the wheel, or are we just going to try to kick it out for 3 years, essentially on same or similar terms? What is each side's motivation, and the likelihood that there's going to be significant asks for changes from the current agreement? And I think that's a conversation that he has right out of the box, whenever one of these is coming around, is how much involvement do you feel you need or want in a particular situation?
Thank you.
Please describe your experience in handling tax foreclosures, tax sales, including delinquent mobile homes.
Okay, I'm Matt Willis. I'll take that one. I've done foreclosures, I've done tax sales, and I've done tax sales of mobile homes, okay? Mobile homes are very difficult. There's no two ways about it, because over time, their value goes down, and if somebody doesn't pay taxes, sooner or later you're in an underwater situation. It could be too soon, The best thing is to try to keep on top of people like that and develop a policy where you might be, for something like that, usually you have to use a tax sale, but you want to do it sooner rather than later. Commercial properties, same thing, any kind of properties. I was in one of my municipalities, there was a house that had accrued $150,000 and change in taxes, and it was a house. And I think it's important to try to address those things sooner, so that people know that you're going to collect the taxes and you mean business. That's a and it's always a touchy thing, because they're taxpayers, they're members of the public, but on the other hand, it's clicking away at 18%. So it's better to, I've had property owners thank me for starting a foreclosure on them. And I know that sounds weird, but they said, we didn't realize it was 18%. We didn't realize that it's kind of like a credit card. And so, depending on the circumstances, but yeah, no, I have experience in all those.
Thank you.
Okay, so what experience have you had in working with policy issues that have been viewed as operationally obstructive? And how have you reworked policy to remove those barriers? So from a land use perspective.
So you're talking about you're not talking about any internal framework in terms of the way that you're operationally working within your department. Are you talking about zoning regulations and other kinds of constructs that are a challenge?
Yes.
can you elaborate a little bit on what any concept you have in mind in that? Because what we have, we've done everything from rework entire sets of zoning regulations to meet, we've had a town that wanted to go with form zoning, and that is a complete overhaul in the manner in which they are zoning the town, and between a consultant being involved and as the town attorney, they worked on completely changing the way that worked. We've worked with towns that wanted to better embrace affordable housing, better understand ADA and the Fair Housing Act, and how to try to get out in front of some of those things. Now dealing with some of the new legislation that's come in with the accessory dwellings, cannabis. When these things come around, we try to do client alerts to our planners when it's a land use related one, and to the town in general when it's not. When we see these kinds of issues, and simply try to get ahead of it. Now, I'm not sure I'm answering your question, but those are some of the approaches we've had to take to face new changes. And every town is different, so when we get involved as a town attorney, there might be something they've been trying to tackle with for a long time. And once you understand it, just like Rich was talking about with Duncan's approach, you communicate, you understand. We might have an angle you hadn't thought of before, and then finding a way. What's the best way? Is it point A to point B, or is it a multi-step process to get where you need to be?
Well, and I think a good example is the ADU legislation, all right? Because every town comes out a different way on the policy aspects of accessory dwelling units. But we have been advising towns that regardless of where you are in that policy, you probably want to opt out and develop your own policy. Because you can have the exact same one as the state, or you could change it, but if you don't opt out, you're going to be locked in. So, I think that's like a policy example, where you can still be doing the same policy, but you still want to opt out.
One other one that just comes to mind is that I know, one particular town that I can think of where they have kind of a business commercial corridor that was languishing. So there was a study done, and then in response to that, planning and zoning redid the regulations to kind of create incentives and opportunities for adaptive reuse, mixed use, some other things like that certainly were not what was in the old sets of regulations, basically designed to allow for more creative and economically viable uses of particular properties, with 100% lot coverage, shared access, those kinds of things that, that had often been kind of poo-pooed in zoning regulations, just basically to create the opportunity for, things to happen in a particular area.
So, with that, what was your approach? How did you help the town get from that kind of operationally, we're stuck in the old way, to a form-based code or that new mixed-use regulation?
Well, actually, it was a town that we were both representing, and I was on the Planning and Zoning Commission, so we worked with a consultant to draft the regulations, and then, as time has gone on, we've seen situations where potential developers have come in and said, well, what you've got is great, but we could really use a little flexibility here and there. And so it's kind of a work in progress to accommodate within the confines of, public health and safety, and not being unduly oppressive to the residential properties behind it.
Another thing is identifying, where the pressure point might be. 'Cause in some instances, we'd have a planner who has an idea, but really needs some direction. Is this a direction we can go in or not? And we can educate them that, yeah, this is an opportunity, but unfortunately, the case of, the McKenzie case says you can't adopt that kind of set of regulations. So here's another way that you could do that. Now, another instance, it might be the commission itself might be resistant to an idea that the planner has. One thing we offer to our towns is training sessions that we come down, Rich and I are both on the Connecticut Land Use Academy faculty. We were also both involved in coming up when the new legislation came in that all land use personnel have to have some training. We were, and then our group was part of reviewing and helping add to that curriculum of what's going to be used as a uniform. OPM adopted it as a uniform training for land use people. There have been instances in which there's some ideas. We've worked it into a training session to educate a commission about this opportunity that they have, and maybe it had a commissioner who'd just been there for 25 years and just really the light didn't go off that this might be an opportunity and has changed the minds of a commission. But it really would be having a better understanding, working with you, and trying to see how we could best help, whether it's helping you, whether it's helping advising the commission, or maybe the other aspects of the administration in the town.
Thank you. So also, land use issues have been a contentious part of town business, many places. That's how it goes. Please tell us your experience in handling appeals and decisions of the zoning board, planning commission, or zoning commission, and other land use issues. And tell us about a particularly difficult land use issue that you managed to a successful outcome.
Well, the first part is easiest. Done a lot of them, so to come up with one that had a most interesting, successful result. But the approach is, in some instances, we've been involved when we know something is going to be controversial in the first place. So we are actually at the table during the hearings and have a pretty good handle on what some of those issues are, and it helped guide staff with motions and the like. Other instances, the knock comes on the door after the application has been decided, in that case, we have to get up to speed of what the case is really about. And with all municipal litigation, not just land use litigation, one of the first things to look at, is there an opportunity to settle it? Is there a middle ground that can end the litigation sooner rather than later in a way that avoids the worst case scenario of an unsuccessful result after litigation, but you end up with something that still works well for the town. So that's something that we will do very early on. Examples of ones that have worked out well often involve ones that we've avoided having to go. We could tell you the war stories of the one we've just gone to the end and just won, but I don't think that really answers your question. Which ones have we gotten more creative with one? One was I can think of was ADA, actual ADA litigation, in which we worked with planning staff where there was a house that was going to be used for care for persons who were coming out of an inpatient rehab facility for addiction. And they were going to use a house that was very well suited for a larger number of people than what was defined with the family. And there's ADA law and fair housing law that says you need to be reasonable, accommodative, but like some federal guidance, it wasn't very helpful. It said if they want to put 20 people in a house, that's too much. But if they ask for 6 and the definition of a single family is 5, that would be reasonable. I'll say, okay, that helps a lot when what we're talking about is 12. And so worked through that and actually guided the commission to, actually the ZBA supported a decision by the zoning enforcement officer to grant the accommodation. And there was a lot of liability that the town would have faced in that, and educated on that, and I think they made the right decision of granting the accommodation. Neighbors did appeal, and we successfully defended the decision. So there was, and the home was established, and there's not been any problems in the neighborhood. So that was one where we avoided a lot of potential civil rights liability to the town. We worked in some compromises in terms of, the conditions that they had the house do for protecting the neighborhood, and I think it was a good result all the way around. That's one that comes to mind.
And now, was that something, did you need any outside counsel dealing with that, or was that everything you did all internal?
No, with the risk of sounding cocky, people come to us for outside counsel on land use work. There's literally no land use work in Connecticut that we don't have some of the best lawyers in the state on. So no, we didn't need outside help on that.
All right, thank you.
My first question was going to be on responsiveness, but you did a thorough job answering that in your presentation. You've talked about the depth of how many people you have working for you. So let's say one of you three are unavailable. We're used to working with one of you. You're unavailable. Do you always have someone that could step up and take your place when needed?
Yes, our staffers, our administrative assistants, they have access to a group of, you saw the list in there, and I don't know if the number is 12 or 14. There's probably 6, 7, or 8 of us that would be like can handle the first question on a general matter and be able to point you to someone who's more specialized if it's necessary. But our staff people know how to reach everybody. So if for some reason the 2 or 3 people that you have as your initial contacts just coincidentally are all out of pocket, they would know how to reach out to somebody else. An APB to all our municipal lawyers, and they have all the municipal lawyers' cell phones. So in a real emergency, we've got a lot of depth.
Yeah, I mean, and we communicate very well among one another, so that it's like, if one of us is going on vacation, we'd tell our assistant, make sure to let so-and-so know if we get any phone calls. We all have very bad habits of looking at emails, when it's not office hours. And, it's like, if you're not going to be able to respond to something, I'll forward it to Ken and say, could you please give her a call and see what the timing is on this? And, try to make it just seamless and transparent.
It's literally happened, for all of us. We're at a hearing, and we're at maybe a sort of a dull point where we look down at the phone and somebody's calling, and exactly that's happened. So it's right in the middle of a hearing. We're able to send somebody to Rich. Rich is able to make the phone call to somebody else who's in a crisis in the middle of a different hearing that didn't expect to need us. So we're able to provide that.
Great. Now, Groton has worked with the same legal firm acting as town attorney for more than 30 years. How would your firm work with the former town attorney to make a transition smooth if you were the successful bidder?
It's a small stake. We play well with others, and that's and fortunately we don't often lose the job after we've represented with people, but it happens. Sometimes it's political, sometimes it's not, and we know how that works. So how we've done it in the towns that we've recently taken over is. Sometimes it doesn't make sense. You have a case that somebody's invested a whole lot of time in, and to start somebody at square one, sometimes it doesn't make sense. So we work in many instances where an outgoing town council continues to handle X number of files. I mean, the way, we start with you of what your perspective is, and are there some things that you think would be best staying with the other attorney? And let's just say in the extreme, you want literally every single thing to come to us. I mean, we would sit down with your former counsel, go over things. I mean, we've had lawyers retire and literally sit and go through their whole their whole sets of files, and it's just professional on both sides to be able to do that. Because if somebody's represented you that long, even if they're disappointed that they haven't been selected to continue, and they realize you can only manage the team for so long, we haven't ever had any problem with an outgoing attorney not working well with us, and vice versa, not being able to communicate, get some of the insights. What should I know about this case or this person or this negotiator? If it's labor, Duncan talking to whoever's been doing the labor and understanding what's their insights with the different collective bargaining units. That kind of approach. Each one's a little bit different, but that's the approach we take.
Great, thank you.
Thank you. What do you perceive the town attorney's role is in dealing with the council, and do you give specific recommendations, or do you give available options and let the council pick?
It depends. How's that for a good lawyer answer? one important thing is we don't give you the answer that you want simply because that's what you want. There are times, it's not often, but there are times we're telling our municipal clients, no, that's not permissible. That would be a mistake to go down that road. Very affirmatively say that because we believe there's a clear answer. More often than not in this business, the answer is closer to the color of your jacket, and it's gray. And we have, because we've seen a lot of different things, we may have a sense of how, if it ever got challenged, what the likely result would be. But then there's also the thing that Rich would say, and I'll let Rich or Matt speak to this topic as well, but there's the practical reality of things too. It's like, okay, you're right, you'll probably win this if we had to fight it that far. But is this the fight you want to fight? Is this the hill you really want to die on? This might be a better way to go and try to give practical advice to the council. So we see ourselves as advisors, try to give you common sense advice, and in some instances there are more than one option that we'd lay out, and more often than not we'd have a recommendation of which one is better, and every now and then we have one that we'll strongly recommend against.
No, I think that sounds right. I mean, depending on what kind of issue it is, sometimes there's an obvious issue, obvious answer, and we're not going to spend a lot of time arguing about that, particularly if it's one that that the town wants to pursue. But I mean, if there are kind of caveats or speed bumps along the way, here's something you might look at as an alternative way to achieve the same result without exposing yourself on, these particular issues, or, here's something that you could put into the contract to try to, protect yourself against the downside, or, here's an exit ramp that you might want to build into a contract, those kinds of things.
There's another nuance. It's really not exactly an answer to your question, but there's just something I also point out that we have enough experience to appreciate, and that is the council's made up with a bunch of different people with different ideas, perspectives, etc. I haven't worked with yours, and some agree to almost everything, but every now and then there's a person on the council or a couple people on the council that are slowing down business or have, it might have an axe to grind or something. Not that it's bad-spirited, but there's a group dynamic that we appreciate and try to also find ways to help with a solution that's going to work for the group, and deal with some of the dynamics we see exist among the members of the council. Never lose in sight that our client is the town, the overall town, not any one member. It's what's best for the town. But you need to you have to be paying attention to some of those human dynamics to help advise the body as a whole.
How do you go about explaining complex or difficult topics or rulings to council members who are unfamiliar with municipal law?
Lots of Latin.
Lots of Latin. That's the subject I failed in high school.
No, I think you just try to be as straightforward. I mean, pick whatever baseline, understanding communication level there is, and just sort of work from there. I mean, I don't want to insult anyone's intelligence by using, stick figures or anything like that, but I mean, you assume that people understand kind of the fundamentals of a transaction or the law, and if, during the questioning and answering, it becomes obvious that maybe they don't, you just sort of back up and say, well, unfortunately, towns are limited by state statute, and this is the way you need to approach certain things, or these are the powers that you do and don't have under the charter, just so that everybody's kind of starting at the same knowledge base and position in terms of understanding the transaction. After that, I think some kind of visual outline, maybe just bullet points or something, a PowerPoint, so that if it's truly complex, you can do sort of a flow chart so that people understand, after you go to the zoning commission, here's the next step. It can either be appealed or not, then it goes to planning for the 824, and then, what the steps in the process are, what the issues that might come up are, what everybody's jurisdiction is, those kinds of things. Again, you don't want to insult anybody's intelligence who's been an elected official for 40 years, but, if you've got new folks on a board or commission or the council, it's probably better to err slightly on the side of, starting with the basics, just so that there's no fundamental misunderstanding as to what the town's capabilities are.
We approach it the writing, too. For writing, it's one of the toughest things to train young lawyers about is understanding their audience. You could take a legal issue and you could cite 14 cases and all the nuances of how the different judges looked at it. And the reality is, if we're advising the council, a lot of that information is completely irrelevant, and it doesn't matter. Sometimes you do reference a case, and this is what the case says, or this is specifically what the statute says, but usually you don't need to be. So if you try to understand as best you can who the decision makers are and what they need to know to be able to make sound decisions, you break it up into kind of pieces, parts that Rich was talking about to be able to help you.
What is your experience and expertise in reviewing or preparing contract documents for construction projects and services that would use local, state, or federal funds?
Well, in some instances, I reviewed contracts. Richard, you probably all have reviewed contracts that involve certain state funding requirements. When it's a contract that involves a complex construction contract or one that involves AIA, those are when we get our construction. We have two construction partners, Al DiVincentis and Bill Wilson. So when I see a contract, and I think both Rich and Matt would take the same approach, that involves some complex issue of construction law, it would go to them. When it's public, just some public finance limitations to make sure that you're complying with whatever grant responsibilities exist under the state or federal grant money, that's something that we would often review and provide advice on, but it's something that we regularly do. Rich probably the most among us.
I just did it the other day. We had an instance where I got a call from a finance director, and he said, our current town attorney is having trouble with this AIA contract. Do you guys have anyone that has expertise? And I put him in touch with one of our construction lawyers, and he was talking to him that day. So, it does happen. It does come up in different circumstances because lawyers can't do everything. One person can't do everything. So it does come up.
Yeah, and both Al and Bill have the benefit of having been in construction before they came to work for us as lawyers. Al was a project manager for a construction company, so he understands the basics of it. But I've had him work on, he's working on a school project for Killingly right now. He just did the Putnam Municipal Complex. Doing a roof replacement in Granby. He did the Weathersfield High School. He's working on the Farmington High School. So, he's fully up to speed on that sort of thing.
Okay, great. And what is your experience in performing research in matters of municipal land and right-of-way ownership determination?
Land right-of-way?
Yeah, land parcels or right-of-way.
Yep. I'll let these guys both do. We all have done a lot of land work, but the tooting their horn, both these guys are folks that get engaged by the state, the Department of both DEEP and Department of Agriculture to do evaluations of land records and often dealing with rights of way. So with me toning their horn that way, I'll let them jump in.
You go.
Well, I've been doing it for many years, so it's really how I started out as a lawyer. Was doing title searches and title issues and title disputes. So I feel comfortable with the rights of way or whatever other issues that might come up in a municipal setting or in a private setting. So.
Yeah, a lot of times, you have to figure out whether, how a road was created, where the right-of-way really is, whether it's just an arbitrary width from the center line or whether it was actually ever dedicated. And I know that Ken litigated one to the, I don't know, Supreme Court on that not too long ago for a town.
Thank you.
Please describe your level of knowledge in the appraisal of commercial properties, in particular considering the income approach to value.
I've handled assessment appeals, all different kinds, whether they're commercial, residential, solar, whatever the case may be. And I think that the issue is always really, the towns are always up against the wall because the legislation has to change. Because right now, anybody, and some businesses do it every year, regardless of what the numbers are. They're filing, whenever there's a new reval, they're filing appeals so that they can try to get some money out of the town. So it's really a numbers game, and it's trying to figure out what, what kind of appraiser you can hire that you think is going to be persuasive in that field. I mean, recently I had one in a, it's still going on, but it involves horses. So it wasn't anything I knew about, nothing I was familiar with. So I had to hire an appraiser that would know how to handle horse properties.
Now, I'm not sure that you caught the whole, part of the question, though, was the income approach. Did you want a specific comment on the income approach, how that factors into some appeals?
I did.
Okay, I don't know if you caught that part of the question.
Oh, okay, so income approach, yeah. So you want to, if you have income producing property, that's what you're going to look at to try to determine, what your rates might be and see if they're accurate. I mean, I always find it fascinating that you'll have appraisers on the same property that can be off $5 million. One's at 10 and one at 5. I mean, that's really something that is means you have to sharpen your pencils.
Okay.
Yeah, not here tonight, but we have 3 other attorneys in the office that do a lot of assessment appeal work. Mike Collins, who is part of our municipal practice group, had been in-house with the city of Hartford and handled, most of their tax appeals while he was there, and many of them since. Jim Perito does the same thing down in New Haven, and Morris Boria does it, both for property owners and for municipalities. And I know that I had referred one to Mike relatively recently where the income approach was the issue because in COVID there was no income. So they were trying to claim a dramatic diminution in value of the property based on what revenue was being generated by it. So I think not to punt entirely, but I think we do have folks on the team who are absolutely up to speed on that sort of thing, and I'm just not one of them.
Yeah,
Okay.
we've handled hundreds of tax appeals for towns, so there, that approach that has come up. We've handled it.
Okay. Thank you. Please describe your knowledge of handling tax appeals for commercial and residential waterfront properties.
This is me again. Okay. So, commercial properties, I've kind of described some of the ones that I've handled recently. Residential, waterfront properties are always specialized. They can create a little bit of a situation, but in the end, with residential properties, most of the time you're looking at comps. What else is similar to this property and where you are? And those are the ones that end up being the more difficult ones, or waterfront, or something that has a special value. Because most residentials you can find a comp with easier, but some waterfront properties might be a little different than another. So you have to look at the different features and see if they line up. I mean, quite often during a reval, those are the ones that create the issues. And so it used to be people would put on assessment companies would put on like a view assessment, which, would get people riled up on, there's just better ways to do that to try to reach a value that you think is appropriate.
And back to the, how the breadth of the number of them, what comes with that is the breadth of number of experience with appraisers, which are such a critical part of those cases. I have been involved in a few, but not nearly as much as the Matt and the other people that Rich had mentioned. So we do have the resource of having lots of experience with lots of appraisers.
And one of the things that's happened in the last few years is anything in the court system has slowed down. So it's created a situation where you have backlogs in almost nearly everything. So if you have the ability to try to resolve something, I think it's beneficial rather than, you don't want to have a lot of tax appeals. I'm fascinated by different towns and how many tax appeals they have, depending on the size. And some towns may not seem that big, and all of a sudden they have a lot of tax appeals. So is there something else going on? Is there another way to look at things? There was one town that had so many tax appeals, the town council didn't actually know how many tax appeals there were. And so at a certain point, they had to get another assessor to get that straightened out, because their budget was starting to get impacted because they didn't really know how much they were going to pull down for taxes. So.
Okay, thank you.
I'm going to go back around for one more time, and if you are satisfied, feel free to pass. We have about 12, 13 minutes or so remaining.
If you were our town attorney and were assigned an investigation, what is the process or steps you use for conducting an investigation, and would that differ depending on the type of investigation?
Let me interrupt for a second. I was thinking we started earlier. We have till 6:30, don't we? So we still have quite a bit of time. We still have about 40 minutes.
Right.
Yep. Sorry about that.
I'll answer the second part first. It could depend on what the nature of the investigation is about. And we would reach out, because we've talked about our municipal group. When there's an investigation like that, more often than not, there is something unique. Maybe it involves a police. Sometimes I've had some instances where there's been internal investigation with police, and they wanted a separate investigation to be able to do that. We'll look to the people in our office that have done something like that and are best suited for it. And the approach is to be thorough. I mean, that's one where you want to be able to gather as much information to be able to give a comprehensive report on whatever the topic is that you want to hear. So thoroughness, getting persons who have the time and the ability to be dedicated to do a thorough investigation and write a report that gives that kind of detail. Because if you're asking for investigation, that's what you're looking for, an unbiased view with a lot of in-depth investigation of facts.
Yeah, we had to do a investigation that was sexual harassment claim by the administrative assistant regarding a former elected official, and there was a tremendous amount of documentation that was provided, and because of the sensitivity of it, we had to do a thorough, careful, and discreet job, and that was what was done. So,
Thank you.
So you actually answered part of this question earlier about reasonable accommodation about your 88 case. But what is your experience with interveners into administrative proceedings and excessive freedom of information requests?
Well, I think I'll jump on both of those.
Yeah, really. Huh?
Quite a bit.
We feel your pain.
The FOI side, I mean, they did adopt, they did adopt this section in the Freedom of Information Act where you were able to make the complaint to get the commission to bar somebody from making those claims. It's kind of a high burden, so most of the time it's been an easier task to respond, but to educate our towns, there's this tendency, people are starting to think that FOI is like litigation discovery, that you can ask questions, and all FOI is intended to give the ability to provide access to documents and to provide those. So there's been many instances where found after the fact that people have gone and basically generated a report to respond to an FOI question rather than does the document exist? If the document exists, let's copy it and provide it. If the document doesn't exist, you don't have to. You don't have to do the research. So that's one aspect on the FOI. There's also a personal element too. I mean, sometimes there's people, as you know, that have an axe to grind for that. And if there's a way to get to the point of what they really want and get information to them that satisfies what they want. They might have this enormous breadth of information they're asking, but then when you look into it, it says, isn't this really what you need? And provide that, and we've accomplished basically making an agreement with folks who are doing FOI requests, but feeling as though they're not being shut out of the process and they're being worked with. That doesn't change the fact that occasionally you just get crazy people who want to make your life miserable, and that's what they use the FOI for. And then you might have to go to that next option and file for that request. We work with FOI quite a bit. Tom Hennick picks up our phone whenever we call him if there's an unusual issue, and we've done that. Now, on the intervention petitions, quite a bit. Handling 2 of them right now. I've got one that is going to, that is going to be before the commission in a couple of weeks. Had one that had 9 hours of hearings with 9 different experts. So on that case, there was really an instance where we had to work the commission through countervailing experts on both sides, all dealing with the question of whether or not this work that involved blasting was going to result in introducing existing contamination from a different site into the bedrock well. And it was very complicated on the science, and they had to make the determination of whether it was reasonably likely to result in harm to a natural resource, and if so, they could still permit it. And so we had to guide them through that process. Conversely, we've got one that's coming up in a couple of weeks where there were a lot of allegations, but there really wasn't a lot of evidence that was presented. So we will be advising the town to make those same facts, and that they have to look at the record and see, is there facts, what's the natural resource? A lot of what they were talking about was noise, and that's not, if they tied the noise to having an impact on a nesting bird in the nearby wetlands, well, that might sort of ring the bell to warrant making an adverse finding. But when you just don't like the noise, but you don't tie it to a natural resource, you've got a problem. So every case is different, but we've handled a lot of 22A19 petitions.
Yeah, sometimes you get an intervention that's not an intervention, where no one makes any kind of allegations. They just say, I'm intervening, and they have an affidavit. So they run the spectrum.
Or they do one where they ask for intervention on issues that aren't within the jurisdiction of the commission. They're not allowed to do that. They're only allowed. So you got to zoom in on what does the jurisdiction of the commission have. That example with the groundwater one, the special permit regulation in that particular town allowed them to consider all environmental considerations. So it couldn't have been any broader. So that opened up the door to just about anything. But we will look and make sure that they're tailored to whatever their jurisdiction is, because there's a case that says that a 22A19 petition doesn't turn a town into a little environmental agency. You've got to stay within your lane.
Thank you. Hey. As I mentioned, you had answered some of my questions earlier, but I'm just going to follow up on that. Have you had any town get to the point of needing a vexatious request or determination from the FOI?
we had one that we did, that I'm aware of, that we weren't involved with, that they made the application, they actually had a favorable finding, but I just learned of it.
It's pretty new, yeah.
It is new,
Yeah.
and I think it's a relatively high burden, but I'm aware of one, but I haven't processed one.
No, I mean, and we've been the recipients of FOI requests from people when you call Tom Hennick and say who it is, he just goes, oh, but there's enough legitimacy to what the person is asking for that it's not solely for the purpose of harassment. That is how the town may perceive it, because the request is so broad, and that if you go through the exercise of redacting and assembling the documents, the individual is never going to come in and look at them. He just wants to make you do the work. But I don't think we've ever had anyone get to that point. I mean, obviously you're aware of it enough. Where it gets to be a problem is some of the smaller towns where either the first selectman or the town manager is like, this person just keeps asking me for stuff, and they ignore them. And I remember distinctly one time going to the town manager's office in a small town shortly after we took over, and he said something like, yeah, I got like 200 emails from this guy, asking for things, and it's like, well, are you going to open them? No, we got the complaint instead. So.
This isn't exactly your question, but the other one that gets more complicated is electronic stuff. Is some towns are better than others to keeping everything within a town server, using town email addresses, and managing all that electronic stuff. So when there's a request, IT can help generate searches to try to find these emails rather than everybody do that, and also counseling people. If you're using your home computer for all of this, there is a risk, not just an FOI, but if there's litigation, that you're going to have someone having a right to get access to your what might be otherwise personal information to get through. So, but getting we've got one right now where there's requests for texts between the phones that the local officials have from a window of time, and text are a harder thing to get your arm around, whether or not those things are saved at the carrier, whether they have any of that, and how far back individuals have that. So sometimes the electronic documents are getting a little bit harder to track down in some towns that don't do as good a job as they might be able to make sure all the information is in a database that their IT can search through.
Great, thank you.
How do you handle a situation or a question, excuse me, how do you handle a situation or a question from a representative of the town that may be unethical or in violation of local, state, and federal law?
All right, so in the first part of the question, is this a question that's like coming from the floor, or is this a question that's coming from a member on the council? I'm at a council meeting, or Rich is at a council meeting, Matt is at a council meeting, and they get asked something. Is this a formal request that's come to us, or is this something that has come out in a meeting that is clearly out of bounds?
Council.
Council?
Yeah, but as opposed to public asking.
Yeah.
questions.
Okay.
Yep.
All right, so it kind of ties a little bit back to what I was saying earlier on, is that we are going to tell you the truth. And if something is flatly impermissible, then, we'll talk about an ADA combination. You get somebody on the council who says, why are we going to worry about, having, some drug addict be able to whatever? That's out of bounds. I mean, that's recognized. A person has protections. As a person with disability, there's accommodations. So if someone is going to, I would do it in a polite, educational way, but would very much point out that the law is well settled in that area, and that person is entitled to federal law protection in that way. So that's just an example that comes to mind, but it could be something much more boring, like wishing they could do some kind of something with accessory dwellings, and you haven't opted out, and we just say, well, this is what the statute says. Or if you hadn't adopted a cannabis moratorium, and somebody comes in and files a site plan application we're going to tell you the truth. You got to handle that like the most similar use under your regulations. Doesn't matter if you think you hate the idea or you're not. This is what you have to do, and we'd be direct.
I'll pass also.
Bernice, are you done? Do you have another one?
So mine is labor again, so I will pass.
Perfect. You have another one?
Yes. So this kind of follows on the one I just asked. What experiences do you have in providing training for municipalities, councils, municipalities, on public records, public meetings, and FOI?
Want to cover that one? We got a lot.
Yeah, we do that.
We do it.
Yeah, we've given the training both to clients on a, one-on-one basis, as well as providing it through CCM, running effective meetings, freedom of information, and so forth. And, we provide a variety of different trainings that are general ones. Actually, when I was pulling up to the building, I remembered that I had done an ethics training here for CCM about 15 years ago. And I I'd forgotten about it until I saw the building, and it's like, oh, yeah.
I had a Zoom training thing Monday night with the town, with their various land use commissions, just about general procedures, public hearings, conflict of interest, things like that. So, yeah, we do them.
Yeah, and we have one specifically designed. We have some towns, what they'll do is they'll call a joint meeting of all of their boards and commissions, because that's one that has broad appeal, can be the council and all the other of their commissions about, not just basic FOI requirements, but some Roberts rules and how they can be used in a way that tries to block business rather than moving it along and helping people understand that they're not hard and fast. They're a tool to help you move business, but and the role of a chair and how they can do within the parameters of FOI. You can hold hearings and answer questions, and every town has their own flavor. But some towns have found that effective to have a joint meeting if it's strictly going to be on running effective meetings and FOI. And then we've also tailored them to a zoning commission or a ZBA. Sometimes we get a town, brand new ZBA, no one's been, we're one member and everybody else is new. So we'll come in and have a tailored training session to give them the basics for that. And then inevitably we'll work into that some of those kinds of things, basic FOI, notice requirements, and fair hearings.
Do the towns usually reach out to you, or do you sense, I think we have a need for some training here, and you'll go, I think we should do this?
We let them know that we do this, and then sometimes we get the bat phone that calls up and says, we need you soon.
Yeah, and sometimes the Freedom of Information Commission is telling them that they need training, or we can offer to do the training jointly with Tom Hennick, and that sometimes turns down the temperature a little bit in the nasty gram, but yeah, I mean, we've done a lot of these, and
quite often the staff to land use commissions will say, we have a lot of new members, so they need some basics. Can you come in and do an hour presentation? Or so that happens a fair amount both ways, but usually it comes from staff or the chairman who wants to keep their commissions up to date, or their new commission members kind of on board and on task.
yeah, I mean, I've found that people who are elected to office who live in the real world are sometimes blown away by the requirements of freedom of information. And what do you mean we can't go to executive session anytime we want to talk about anything? What do you mean my letters to each other are public documents? Those kinds of things. It's probably better to have the rude awakening really early in the term than, later on.
Cool. All right, thank you.
Right. That was all our pre-planned questions, but I will ask, is there anything you didn't cover in your presentation that you might want to express to us about your services you would provide that may have been sparked by questions along the way?
Well, one thing that concerns me, but I mean, if you wish to reach out to me to pass on, it's unfortunate that Duncan couldn't be here because he's out of state, and Jen had some last-minute childcare issues that came out. But it seems as though I don't think we did a bad job of doing our best, having not done that work, to answer some of your questions in the labor world. But by all means, if you wanted to pass those on and get a short response from Duncan or Jen, we'd be more than happy to do that for you. So that's one area that I'd like to be able to cover better, and I can't right now, or we can't right now.
And even though we're lawyers, we don't necessarily make stuff up.
That's not what I heard. Okay, thank you. I appreciate it.
That's what you can't tell we're lying because we're in the
I appreciate it. We'll be back to you soon. Thank you very much.
All right.
Thank you.
Thank you very
Thank
much.
you. Take care.
Appreciate
Good
having
seeing
the
you.
opportunity. And look forward to
Take
meeting
care.
you.
Who wants to sit next to me?
Do we have enough chairs?
Just enough.
And when you talk, make sure you move.
reserves outside.
Yeah. And when you talk, make sure you pull. There's only 3 mics over there, so make sure you pull up towards you when you're speaking.
Okay.
I am, yeah, thank you, I'm fine.
Okay.
Ready, Liam? Okay. Welcome, everyone. We do have a couple people that may not know each other, so why don't we go around the room and introduce ourselves. We're here with Sussman Shapiro, and start with Eileen.
Hi, Eileen Duggan.
Rich Cody.
I'm Ray Baraba. Eric Callahan.
I'm Christy Kelly.
I'm Jay Barryman.
Nick Keppel.
Nick Keppel.
Let's go into this case because we some people might not have met a couple of us. So.
Mary Gardner, I'm the assessor.
And for the public.
Eileen Cardillo, purchasing agent.
Greg Hanover, Director of Public Works.
Bruce Jones, Town Council.
John Burt, Town Manager.
John Reiner, Director of Planning and Development.
Melissa McGuire, the tax collector.
Ernie Green, Director of HR and Risk Management.
And welcome, everyone. The format is you have up to 30 minutes to do a presentation, not required to take that much time. And the total length of our slot is 90 minutes. Once we're done with the presentation, we'll go around and ask questions and go from there. So.
Great. Well, thank you. Again, hello, everyone. My name is Eileen Duggan. I'm a partner at Sussman Shapiro, and along with my partners here today and other attorneys at our firm over the years, we've served as the town attorney since 1984. On behalf of us all, thank you for inviting us to participate in this interview. And we know that the town is a choice and its legal representation, and we never take a town attorney appointment process or our continued representation for granted. So over the course of our opening presentation, and then in response to your questions, we'll demonstrate how Sussman Shapiro will continue to meet the essential expectations of a municipal attorney, providing sound, efficient, practical, and objective counsel at a reasonable cost, plus much more. Once this panel has considered all the candidates, we trust that the panel would consider our reappointment to be in the town's best interest and respectfully request that you recommend our reappointment to the town council. With our history of providing municipal legal services in general, combined, the current partners at Sussman Shapiro have over 250 years of municipal legal experience, as well as our partnership with the town dating back to 1984. We feel that Sussman Shapiro is uniquely situated to continue to provide the town with timely, comprehensive, and thoughtful legal advice. Throughout our service in this non-political position, we have worked with over 15 town councils, 4 town managers, dozens of department heads, hundreds of agency board and commission members. We've considered ourselves very fortunate to work with groups of talented professionals and dedicated public servants at all levels of town operations and town government, and have truly enjoyed our partnership with the town and working through issues, whether they're straightforward or thorny and complicated. Throughout our representation, our attorneys and staff have been deeply rooted in southeastern Connecticut. We live, we work, we play, and volunteer here. Our kids have gone to or go to school here. We appreciate the uniqueness of having the subbase and Navy members as our neighbors and understand the importance of submarines and their history here. We all enjoy Shinnecock Golf Course. We enjoy Bluff Point State Park. We have that extra interest in and concern for the town that only comes from being a part of this community. My partners here today are some of the experienced attorneys with whom many of you have worked over the years. And although we've gone around and sort of introduced ourselves, I'm just going to ask everyone to introduce themselves again and explain a little bit of what they've done and what they currently do for the town. So with that, Eric, do you want to chat?
Sure. Again, I'm attorney Eric Callahan. I joined Sussman Shapiro in 2004, and I'm currently its managing partner. My wife was born and raised in southeastern Connecticut, and after my graduation from law school, we decided to move back here 17 and a half years ago, where we are now raising our family and active in the community. As an attorney, I have both a transactional and litigation practice, focusing on municipal law, residential and commercial real estate, construction law, contract and business matters. Through the years, I've had the great opportunity to serve Groton in connection with various legal matters, ranging from assisting with municipal questions as they arise, for instance, interpretation of the charter. We have a bank of decades worth of legal opinions at our resources. Contract negotiation and review. I assisted with negotiating complex construction documents, which assisted in the construction of the schools. Assisting with the town with real estate and grant transactions, representing the town in mediation, arbitration, and litigation disputes. Some of the matters which I participated in on behalf of Groton was negotiating a land lease, which brought the charter school to Groton, preparation and negotiation of unique contracts, such as the one that allowed for the Fitch High School improvements to allow the schooners to come to Groton, assisting with various real estate transactions to assist the town in carrying out its various initiatives like open space and economic development, resolution of the state of Connecticut's wrongful assertion that the town owed substantial sales taxes in connection with the commercial waste program, resolving title, design, and construction issues involving the school, water pollution control, and other construction projects. In fact, we arbitrated one case for 21 days in this very room one summer in 2015. And I'm currently in the process of vigorously defending the town in various tax assessment lawsuits, including the ones with Pfizer and FuelCell, where significant tax revenue is at stake. The Pfizer matter is likely to be tried in May of this year. Through the years, I've been very grateful for the opportunity and very proud to represent the town of Groton, and I hope that relationship can continue. Thank you.
Ray?
Yes. First of all, my name is Ray Barabo again, and I want to thank you all for having us here this evening. I have worked with Sussman Shapiro since 1989, and when I first started in 1989, I almost began immediately working with the town of Groton. At that time, it was with Nancy Ditko, who was your tax collector back then. The scope of my work for the town is a little less broad than Eric's. I focus primarily on the tax collection work for the town. However, in my practice, I'm also engaged in bankruptcy law, whether it be from the creditor side or the debtor side. And with that experience, I'm oftentimes called upon by Melissa McGuire's office, for example, to assist with the bankruptcy filings of one of the taxpayers in order to ensure that the town can collect its taxes. Through the years with Nancy Ditko, Cindy Small, and now Melissa McGuire, we have collected, and I think a lot of this is as a result of the great work of the taxing department as well. I believe you always hit 98 or 99% of your goals each year, and that is no small feat. There are some instances in which obviously tax collection is rather routine, and then there are some instances in which the collection is very difficult. We are there to assist in all aspects of the collection. I pride myself, and I think that Melissa and her staff would tell you that we are extremely responsive in any of the requests that the office makes, and I pride myself in turning around, whether it be a letter to go out to a taxpayer or to see if a foreclosure matter can be resolved. I try to turn that around within a 24-hour period, and I'm always available, whether it be by phone or by email. So I've certainly enjoyed working with the town, and especially Melissa's department, and I would look forward to continuing that relationship. Thank you.
That's great. Christy?
Hi, my name is Christy Kelly. I'm a labor and employment attorney at Sussman Shapiro, and I've been with the firm for almost 8 years now. I've been practicing law for almost 20, and the last 15 of which I've primarily focused my practice on public sector labor and employment law. I've worked at the federal level, the state level, and now the local level, so I have a broad range of perspectives when it comes to personnel and labor-related issues that arise. I hailed from Plainfield, Connecticut, but I live now in southeastern Connecticut. My dad keeps his boat here in Groton at Pine Island Marina, so I'm very familiar with the area, and I enjoy working and living in southeastern Connecticut. So representing the town of Groton is certainly something that is near and dear to my heart. Over the course of my 8 years, almost immediately when I came to Sussman Shapiro, one of the first clients that I started working with was the town of Groton. Regularly work with different department heads and more prevalently with the human resource department because of my focus in labor and employment issues, whether it's answering questions about an interpretation of a pension plan or the interaction between the FMLA, the ADA, and workers' compensation for leave issues, collective bargaining, grievance arbitrations, you name it, it runs the gamut, and I've had my hand in many of different areas, whether it's public works or the police. Issues arise every day, personnel related, so there's always lots of work to be done. What I like primarily about my job is that I can't do my job unless I learn everybody else's job. It keeps the practice of law super interesting for me. So if we're working on a personnel related matter, I have to know my client. I have to have that personal contact with my client. I have to understand their work environment. And to me, that's the most exciting part of practicing law, the advising and the counseling and learning what it is that you and your staff do every day in order for me to be able to effectively advise and assist you guys in making proactive, preventative legal decisions about how you manage your business. That's why I think I still like this area of law and continue to love it every day. One of the more important pieces for me is, like I said, is getting to know my clients on a pretty familiar basis, and I've done that here in Groton. Everybody that I've interacted with, we've become I've become part of the team, and I like that. I like being part of that team, and I hope that we can continue that type of relationship. And in order for you to know more about me, I thought I would tell you, what I like to do in my free time, get to know you, but I don't have any free time. And that's because I'm a mom, I have 3 kids, I'm a person just like everybody else here that has lives outside of work. So I thought maybe it would be better to conclude in telling you what I do when I'm not at work, and that's usually sitting in a lawn chair watching a soccer game or driving the carpool mainly. So I think that when you get to know your clients, and in this type of work, that's my favorite part, is knowing the people behind the work that we do. So thank you for this opportunity, and I look forward to continuing to work with you. Jay?
Good evening, and thank you for having us here this evening. I'm Jay Barryman. I have been with Sussman for 36 years and am rapidly approaching, unfortunately in some respects, my 40th year of the practice of law. I'm the designated pinch hitter tonight because my partner, Rob Kevel, normally handles the accounts for the town of Groton in terms of, and the Board of Education and the workers' compensation claims that are brought. He works a lot with Pam Archibald with the Workers' Compensation Trust, Ms. Lapine on the Board of Ed side, and Ms. Adante on the town of Groton side. One of the things that I would say is that both Rob and I do both sides of the practice. We handle a lot of work for injured workers, and we also do represent towns. I've done a lot of heart and hypertension cases over the past 30 years, and including for the town at one point in the past, although Rob's taken over a lot of that now. But one of the things that I think is unique about that, doing it on both sides, is that you bring a perspective. I think we're very pragmatic in our approaches. We understand the minds of the people that we're dealing against because we deal with it ourselves on a regular basis. And really, when I started as a young pup, they told me that on the defense side of workers' comp, it's all about containment of the case. You will keep it contained so it doesn't run away like a freight train, okay? And that's one of the things that we try to do. We try to be practical, pragmatic, problem solve, and bring matters to a resolution whenever possible. Fortunately, and again, I don't work with the town on a daily basis with this, but I do have enough interaction with Rob, and we talk about our cases to the extent where the people that he's worked with over here have given him the freedom to practice law and to offer pragmatic solutions and pragmatic advice that can bring matters to a resolution. Because again, a resolved case is a happy case. I mean, that's just the way it is. So I appreciate the opportunity to be here this evening, and I'm certainly happy when we get to question and answer to try to answer any questions that anybody may have about any issues in that area of law.
Nick?
Good evening. I'm Nick Keppel. I practiced with Sussman Shapiro from 1989 to 1993, and then I joined a fellow in Stonington and practiced in Stonington until 2 years ago, and then rejoined Sussman Shapiro 2 years ago. Because I served as the probate judge for the Southeast region in Groton Town Hall until last September, I'm coming at this from the perspective of prospectively of what I hope to do in working and what I feel I bring to Sussman's capabilities. So in that regard, I think I bring a few things. I've practiced municipal law for 30 years. I've represented 11 different towns. My colleague and I, who was my partner, now he's my colleague at Sussman, Rob Avina, we've represented Waterford for the last 20 years and do many of the same sorts of things. I do collection work like Ray, do a lot of FOI, a lot of zoning enforcement work, have litigated matters. But in addition to that legal experience, which is described in my resume,
I was born in Groton. I was actually born at Lawrence Memorial Hospital, but I spent the first 6 years of my life in Pequannock Bridge on Quincy Court, and so it was great fun when I was the probate judge to be driving by where I grew up. I played basketball, at the Fitch Middle School, in high school, in the rec program. Taught later in my life, taught courses at Avery Point in international diplomacy, where I learned about a tool that I try to use regularly when getting out of trouble with my wife when I'm late for coming home, called plausible deniability. I love that expression, and I'm trying to teach students about that. But I also, in addition to being very familiar with Groton because of that experience, I was a municipal official. I was the first selectman in Stonington. I was on the board of selectmen for 4 years and was first selectman for 2, until the voters realized I'd be a better lawyer than a first selectman, or at least that's how I rationalized them having shown me the door in 1989. And that's when I lost my re-election effort. I joined Sussman. But being a user, a consumer of municipal, of services, has really helped me in my service to municipalities, because I've sort of walked in the shoes of town officials, and I think that my clients have always found that valuable. I also have another perspective. That my son was a Groton police officer, and he suffered a serious injury off duty, and so I got to see a different side of the town of Groton, and how wonderful, not just the police department and his colleagues, but the whole, human resources, the whole, Groton town community were wonderfully supportive of Benjamin. And then more recently, having spent 10 years serving in the building in a different role than town government, but working side by side, benefiting. Each year I would go to the council and the RTM and sincerely laud, praise the town for being such a wonderful place to host the probate court. When we needed locks or windows or anything done, the town was always just terrific. And one of the things that people don't fully appreciate about the probate court is, first thing it says in people's wills is, the executor will take care of whatever bills, whatever obligations the decedent had, and that included, paying bills like the town taxes. So we routinely would work with the town to make sure that the estate took care of its obligations, whether federal taxes or town taxes. So I feel like by being in the building and oftentimes working with the town, it gave me, a particular familiarity. So I think all of that puts me, plus of course, functioning as the probate judge for 10 years, I had to try to resolve, and I think successfully did resolve, a lot of disputes. And so functioning as a mediator and trying to get issues resolved, I developed skills that I think I can bring to my role as part of this team. So I look forward to the opportunity to work more closely with all of you in the years ahead.
Rich?
Good evening. I'm Rich Cody, and I joined Sussman Shapiro for the first time back in 1987, and I was immediately assigned by Jim Brennan to do the land use work here in the town of Groton, and did that for 5 years, working with Jim Butler at the time, Deb Jones, who was as young as I was back then, and because I was really interested in land use and land development, natural resource development, and wetlands law. And at that time, if you remember, the environmental law was becoming sort of a sexy idea and was becoming more prominent in the legal field. So I applied to a program out west to do a master's in law in natural resource and environmental law at Lewis and Clark University, and I left the firm in 1992 or 93 and went out there to do an LLM. And I believe I was the first attorney in Connecticut to get that degree. And after that, I opened up my own practice and practiced in municipal law. I've always represented towns. When I first got out of law school, I represented New Milford down that way, and then when I came up here, it was Groton right away, and a lot of the other towns. And currently, I'm town attorney for 4 or 5 towns up in eastern Connecticut, including Wyndham. So I've done a lot of municipal work, a lot of land use work, a lot of environmental work. I've argued many cases in the appellates and Supreme Courts. I have several signature cases involving charter interpretation, town meetings, and land valuation where the property is environmentally impaired or contaminated. Otherwise, we know them as brownfields. So I've done a lot of brownfield development, particularly if you go up to Vernon, you'll see how they've developed the old factories, or in Wyndham with the Wyndham Mills. I was involved in those cases, in those matters, setting up the structure for the development, and then watching it go through with the environmental remediation. I'm always embarrassed talking about myself, but I'm admitted to Connecticut courts, the district courts, the United States Court of Appeals, and the United States Supreme Court. I haven't argued in the United States Supreme Court. I'd love to, but I'd have briefed some cases there on land regulation and takings cases, regulatory takings. And when I came back to Sussman 3 years ago, I told my partners at the time, who were going to be my new partners, that something Jim Brennan had always told me. He said, municipal law is something you have to really like to do. And I told my partners, I said, look, I always wanted to go back and work for the town of Groton. And because I share Jim Brennan's zeal and his enthusiasm, he lived in town, and I just loved working and doing the land use work here. So. And I insisted, I said, I really want to continue working for the town. So that was one of the major reasons why I came back to Sussman. And I'd like to continue with that. I also do, as Eric mentioned, a lot of transactions. I work very closely with Eric, working with Mary on the Pfizer case and the fuel cell case. One last thing I can say is I live in Mystic. I'm on the Stonington side. For several years now, I've been the chairman of the Water Pollution Control Authority in Stonington, and we have 3 sewer treatment plants, and so I'm very heavily involved with the water discharge regulation, point source regulation. So I guess we're open for questions.
Not quite yet.
No?
Sorry.
Okay.
So back to me, I guess. I live in Waterford. I've been an attorney with Sussman Shapiro for over 25 years, focusing primarily on municipal law and public sector labor and employment law. I've served as a town's named town attorney since 2006, which is something that's really meant a lot to me, because I have worked with the town and for the town since I began with Sussman Shapiro. I was also fortunate to work with and learn from Hal Kalmar and Matt Oje, both of who represented the town for years, and then went on to become Superior Court judges. I've worked on all aspects of collective bargaining with the town, as well as everyday municipal issues like charter interpretations, ethics questions, and FOIA requests. And I've stepped in to handle some unusual issues. And thankfully, Mary, I think, put her trust in me when we went to the Supreme Court on a Groton Long Point tax appeal a few years ago. I think something that Christy mentioned, too, it's this type of work, you do get to know the people. And I think people know us as people, and I think that really does lend to the representation and the mix of work. For me, all these different things is really what makes the representation of the town and municipal entities really interesting and challenging. So in representing the town, we would continue to stress finding ways to proactively address potential issues and avoid costly, protracted disputes in a manner consistent with the town's objectives. We would continue to provide efficient and accurate legal counsel, which at times means the requester does not receive the news hoped for or desired. In those circumstances, our job has been and will continue to be to explain the reasons for our opinions and to offer the opportunity to discuss whether legal alternatives exist so that the town could reach its stated goals. We go into this knowing that you are the experts in the substance of your respective fields. As such, we don't set policy, but we do provide counsel as to whether a proposed policy or decision by the town passes legal muster. It's our hope to continue to work with you to achieve the substantive town goals within the confines of the law. In preparing for tonight, we really considered the nature of our value that we bring to the town. We strongly believe that our value is not just in our hourly rates, which at $150 per hour for all attorneys, associates, and partners, has increased only $5 per hour since 2005. But, as I think you can gather from the comments that our partners and colleagues made, our value is also in our specific knowledge of the town, which includes, for example, knowledge of the town's current charter, understanding the prior charter revision processes that were successful or that failed, knowing the town's ordinances, helping to develop them, such as the ethics code, the town's knowledge of the town's legal relationships with Groton Long Point and the city of Groton, working on developing an opinion to identify the nature of Groton Long Point as a municipal entity, as well as addressing that class action lawsuit that I mentioned. The town certainly has knowledge, we certainly have knowledge of the town's past master appraisals, previous tax appeals, settlements. We've had a complex or longstanding history regarding the complex assessments at EB and Pfizer. We certainly have knowledge of the town's collective bargaining agreements and histories of negotiations, including negotiation of all the town's collective bargaining agreements, 5 in total, since the mid-'80s. We certainly have that history as well with regard to grievances, arbitration awards, prohibited practices, and understanding to what things were able to get resolved through mediation or other processes. We certainly are knowledgeable about, as Jay mentioned, the town's workers' comp history, as Ray mentioned, the town's tax collection processes. Eric and Rich mentioned the town's construction processes, negotiations of contracts, and litigation to enforce the town's rights. We're certainly aware of the recent change with the land use agencies with the combination to the Planning and Zoning Commission and the process to develop that. We're aware of the town's agencies, boards, and commissions, from those that are typical, such as a retirement board, to those not so typical, such as the Jabez Smith Committee. The Jabez Smith House Committee. In looking at these, our knowledge of these items, very specific to the town, and our general knowledge of municipal law certainly allows us to quickly assess the situation, determine whether and what research needs to be done, and offer timely guidance and counsel. We take pride in our ability to provide timely advice in novel circumstances as well, such as during the pandemic, when all the governor's executive orders changed the legal landscape on a seemingly weekly basis, or when something like the Police Accountability Bill was passed, raising significant and immediate issues related to the town police department and its oversight. We know that our knowledge, or our legal knowledge, based on our years of experience in service to the town, can't be replicated. So in trying to develop the appropriate level of understanding and expertise to provide reasoned guidance, we believe that any new attorney or firm stepping into this role will no doubt spend significant time of their own, meaning monetary cost to the town, trying to come up to speed, as well as significant time of the town's employees, redirecting them from the operational work that they're doing. I mean, part of our value is simply that there is no learning curve with us. The town can continue to expect that in selecting Sussman Shapiro, it will receive clear, direct, and objective guidance. The town can expect the same high level of responsiveness, availability by cell, email, text, if needed, as we've provided over the years. We'll continue to use primarily partners with a significant experience and history with the town and for the town's legal services. I think coupled with our reasonable hourly fee, our pretty stable history of overall fees, we believe that we are the town's best option for the provision of legal services going forward. And we again respectfully request that you recommend us to the town council for reappointment. So with that, happy to take questions.
Thank you.
Thanks.
The format's going to be the first time around, we're going to do 2 questions, and then after that'll be 1 question from each person around. And just to keep in mind, there's about an hour left, so and about 20 questions or so to try to get through. So, Arnisha?
Thank you. We aim to be responsible towards the budget and the best use of time and resources. When negotiating a collective bargaining agreement, or CBA, after how many sessions and at what point might you suggest bringing in a mediator? And then what about moving to arbitration?
Sure, I can jump in on that one. Each negotiation session really is different, and I think we have a good handle on the history of negotiations with the various bargaining units to know, frankly, which units themselves will be ready to perhaps get things done quickly, or with which units we might have to look or anticipate a mediation process. So I think we've done a fair job over the years of trying to size that up at the beginning. Our philosophy, I think, has always been mediation is a great tool. It's cost-free to the town, and something, if you can mediate a settlement, it's typically always better than something that you might get in arbitration. So our philosophy with that is that we're in a partnership, or the town's in a partnership with its employees. The town has to work with and live with its employees and live with the agreement that's reached. So we work with our department heads, town manager, et cetera, and HR certainly, to sort out really what that path will take. In some instances, we have a quick exchange of proposals, and the next session, we're looking at exchanging package proposals because we think we can actually sit down and get through something. Some others have been more lengthy, that's for certain, and because they might involve really difficult issues, like a significant change to a structure of employees, a salary structure, and adding new jobs. Or perhaps it involves a completely different schedule. Like, for example, the police department could propose a different schedule. Those things just may take longer. And again, I think our view, as we've practiced it, is to assess the situation, see where it's going, not set anything necessarily specific at the outset that it's going to take this and then we're going here or this or we're going there to mediation, but mediation is always on the table. And our record here has been pretty successful of negotiating contracts. It's been quite some time since we've actually initiated a binding interest arbitration.
Thank you. Next question, please describe your preferred labor negotiation style and strategy.
Okay, I think that's me again, somehow. My negotiation strategy, again, is it's collaborative. It's collaborative with the town and its HR department and its department heads, certainly to develop what our proposals will be. One of the items that I mentioned in our opening remarks were that, we're not the experts. We have to learn from all of you to understand operations as to how it's going to work, what do you need, and then we see how we can get there. I mean, I will say that perhaps often comes up more in a public works situation or a police situation where there's some of those issues. But then I think I can speak for Christy as well and say we're generally not people who are standing and, pounding on the table or anything like that. Again, the relationship between the town and its employees, that's going to continue on. And so what happens at the table and how that's managed can have either a very positive or potentially a negative effect. And our goal is to ensure that, the town is able to achieve the goals it's set, and more importantly, to be able to go into work, the next day after a contract's settled and be able to feel comfortable and work with their employees again. Is there anything else, Christy, you might add to that? Or
No, I think Eileen is spot on. I think the most work goes into the preparation to start the negotiations from our perspective, in terms of truly understanding what the needs are of the town, to make sure that our proposals match what the needs are, and then the rest of it is really very cordial and collaborative. That's been my experience here in the town.
Okay, thank you.
Can you please describe your experience in handling tax foreclosures and tax sales, including delinquent mobile homes?
Oh, I guess I'll take that one. Well, as I indicated, I started working with your predecessor, Nancy Ditko, in 1989. There was a tax sale that was conducted back then, and the town really doesn't engage in too many tax sales, or hasn't since 1989. We did one with the town, must have been 4 or 5 years ago, and those were primarily mobile homes that were the subject of the tax sale. And I will get to the mobile home situation in a minute, but primarily the tax collection process starts with a letter to the taxpayer, and to see if there's a way that the tax payments can be brought in immediately. If their situation warrants it, there might be the need for a payment plan, which the tax collector is oftentimes willing to accept, as long as it's reasonable and achieves the town's goal in reaching its revenue collection obligations to the town, because payment of taxes is the responsibility of all the residents in the town. So we start off with that, and then if we're unable to reach any resolution, then we will conduct a title search to see if there are any lien holders or creditors on the property, and specifically a mortgage holder. And if there is a mortgage on the property, oftentimes the mortgage holders will not want to be named as a defendant in a lawsuit, so we will reach out to the mortgage holders to see if they have any interest in paying the taxes. And I would say, with the exception of sewer use obligations, taxes are oftentimes paid by the mortgage holders relatively quickly. Some mortgage holders that they just refuse to pay the sewer use, and that forces you into the foreclosure realm. And then once service of process is made, then they're willing to pay. It's an interesting conundrum that they put you in. With the foreclosure process itself, I believe that the last time I was here, when there were interviews, we had talked a little bit about the strict foreclosure and a foreclosure by sale. I would say that primarily most of the town foreclosures, when they are conducted, they go to sale, and the town recoups all of its legal fees, costs, interest, lien fees, and taxes through those sales. There have been a few instances in which the town wound up being the sole bidder at the auction, and so at that point, then the town would own the property and then engage in its own marketing efforts to either sell those properties, or the town might find that there is a need for those properties for future municipal use. You have your property review committee, which examines the properties that are going through the foreclosure process, or which may go through the foreclosure process. I have been involved with your property review committee in the past, and I find that that's a very helpful helpful collaboration of the various departments in the town to assess what its current and future needs are for properties which it may or may not engage in collections. As far as mobile homes, those are very difficult. While they are taxed like real estate, they're really personal property. And most mobile homes are located on rented or leased lots. And for the town to foreclose on a mobile home, it would mean that if the town were the sole bidder, or if it took it by strict foreclosure, then the town would own a mobile home on a lot, and it would have to start paying rent to the mobile park owner. Obviously, that's not a situation in which you want to be put into. On the other hand, mobile homes also appear to depreciate very quickly, and so oftentimes the taxes, especially with the interest, it vastly exceed the value of the mobile home. So we try to get creative. First is we will work with the mobile home owner to see if there are any payment arrangements that can be done, and oftentimes that works. We find that many mobile home unit owners are elderly or disabled, or for whatever reason find themselves being unable to pay the tax in full, and so we will work with the unit owners in order to try to get at least the payments going again. It seemed like that there was a sentiment with the unit owners that, hey, I pay my lot rent, so I don't really have to pay taxes, and the town has taken a concerted effort to change that mentality with its mobile home park owners. We also work with the landlords themselves, or the owners of the mobile home parks, and they have worked with the town in order to try to urge the occupants of these mobile homes to pay their taxes. Sometimes the mobile home park owner will engage in their own actions to get those mobile homes removed. And it's interesting, over the last year or so, it seemed to be with COVID in particular, that mobile homes were selling higher, at a higher value than what you would expect. And we've had a couple instances in which the town actually recovered funds from an eviction, if you will, of a mobile home. In fact, we have one now that Melissa will be getting her full recovery of her taxes. So mobile homes are a peculiar entity, and so you really need to take great care in working with the owners. As far as tax sales, finally, we have done tax sales. We would certainly be willing to do them again. One issue we have always experienced with tax sales is that a lot of the properties in which people aren't paying the taxes, it's because they've passed away, and so obviously they can't pay the taxes from the great beyond. And so with that being said, a tax sale is very difficult to conduct when you have the owners being deceased, because you're supposed to send them certified mail under the statute, and you can't send a deceased person certified mail, and the statute has not been amended or changed in order to allow that. And so therefore that puts you into the position in which you just have to to do a foreclosure. And so oftentimes, that is the recommendation with our office, is that just do the foreclosure process, because the statute then allows you to do publication in the newspaper, and that publication meets the due process requirements that are necessary in order to get the foreclosure completed. We have seen some instances in which other towns have engaged in tax sales, and the owners have deceased, and then when the tax sale is concluded, the owners or the purchasers at the tax sale, whether it be a third party or the town, is now left with a property which is unmarketable. They can't sell it. They can't do anything with it, and then they have to engage in a quiet title action in order to take care of the deceased people and their heirs, because they weren't provided the requisite notice for the tax sale, and that can amount to a substantial amount of money. So our goal is always to try to meet the demands of the town to collect its taxes, yet to try to do it in as an efficient manner without going through the tax sale rabbit hole when it's really not going to accomplish what you need.
Thanks, Ray.
Yeah.
All right, thanks. So what experience have you had in working with policy issues, really namely like land use policy issues, that have been viewed as operationally obstructive? And have you reworked policy to help remove some of those barriers?
In working with the land use agency in terms of developing policy, ordinarily, we take our cue from the goals that the staff and the agency wants to accomplish, and then if we're drafting regulations or zone changes, we draft around those policies in order to accomplish them. Sometimes with zoning policy, depending upon the kind of zoning it is, it will take the form of either a regulation or a zone change, and different kinds of techniques by which you can achieve the balance of regulatory controls with the marketplace. A lot of regulation writing is built around balancing the interests of the real estate market and in property owners, and the interests of the government to regulate it. So I'm not sure if that answers your question.
John, I think I have an example of talking about broad experience, not experience with Groton, but in Waterford, they had adopted a blight ordinance, and the staff found enforcing the blight ordinance was monumentally, complicated, difficult, because, blight ordinances are really, their origin was in the cities as a way of taking properties. And so I don't want to take up the whole evening, but that, when you asked the question, we just did this in Waterford. We basically went back to the RTM and said, this is more cumbersome and operationally obstructive. It's taking up too much of the staff's time. We're not really accomplishing. We have other tools on the zoning enforcement side to. And because of the whole structure, the need to have a hearing and then impose fines, and it just was sort of an administrative nightmare, and basically not worth what the original objectives were. So it was to me an illustration of listening to our clients who were saying, a noble objective to try to clean up properties, but it just was so cumbersome that it was ineffective and hugely time-consuming and a time drain. And so we helped the town go back and explain to the RTM that, and they basically did away with the blight ordinance. If that's the type of thing you were thinking of.
Thank you. Yes, thank you. So also, land use issues have been a contentious part of town business. Please tell us your experience in handling appeals of decisions of the zoning board, the planning commission or zoning commission, and other land use issues. And tell us about a particularly difficult land use issue that you managed to a successful outcome.
Well, over the years, I know the firm has handled numerous appeals that have involved, 2019 petitions, which were environmental petitions, gross zoning, special permit matters. It's taken some up to the Supreme Courts, depending upon the kinds of language. Sometimes in administrative appeals, the language is attacked by declaratory judgment. In terms of working on the appeals, the best way to avoid appeals is really the goal for municipalities, is to just avoid the expense of them, is to just make sure the agencies are getting the advice in advance of making a decision. And one of the things we do, or I like to do, is focus in on the procedure by which the agencies adopt and regulations and also make decisions, and help them with the rules concerning things like ex parte testimony, ex parte evidence, procedure notice, and try to make sure there are no mistakes along the way. But in terms of cases that have taken to the court, they were usually procedural, sometimes substantive regulation changes. But the way the administrative appeal works is that, like a trial court, the agency is considered to be the finder of the facts. And as a result, on appeal, you're actually it feels like you're standing in the appellate court, because you're arguing that the agency's decision was rational. And so the standard of review is you're not retrying the case, so the agency decision is very important that it be sanitized. And one of the things I like to do is offer seminars on ex parte evidence, procedures for agencies, and also freedom of information issues. And I offer those really yearly, and I like to do them for free for the municipalities I represent, because it helps me interact with the staff, it helps me interact with the commission members, but it also makes it easier for me to work with them in the sense that they begin to realize, and in a way that call us before you make the decision if there's a question. Learn how to identify the issues in advance so that we can solve the problem before it becomes a legal problem. And so that is, and I think I've given here an FOI lecture.
Okay, thank you.
But I'll be happy to get you a list of the cases.
Now, your presentation covered most of my questions, so that was very thorough. I'll just ask, obviously you've provided services to the town for a long time. If you were not chosen as a successful firm, how would you work with the new town attorney to ensure a smooth transition?
Honestly, I think that's a little bit hard to answer in the specific situation. I can tell you that in other situations where these have happened, whether it's our firm taking over from another firm in somewhere or vice versa, it's the interest of the client of the town has always been paramount. I mean, we have to ensure that if there is some type of change, that the town's not put in jeopardy because of that. Certainly, don't want to see missed deadlines or anything like that. I think what we can't impart is what I was describing in the initial remarks. We can't impart 30-odd years of our knowledge and history to a new firm. We can say, here's where something is, here's an appeal, But I couldn't tell you that the next thing wouldn't be, well, what happened then? What happened then? What happened then? And that's what we can't do. I mean, it's one thing to try to ensure a smooth transition of a particular matter, and certainly that has happened. But, we can't just say, here's everything we know and everything we've had for, over 30 years.
The good news, John, is that the community of folks that do municipal law across the state, it's a great group of people. The reason most of us have chosen to spend the time we do in municipal law is people that do this love being the people's lawyer. They're serving, their corporation counsel, but it happens to be a public corporation. So, I was the chair of the Municipal Law Committee of the Bar Association for many years, and president of Connecticut Association of Municipal Attorneys, Eileen, and my colleague Rob Avina are on the board of what we call CAMA now. So there's a strong network of professionals so we know most of the folks, and it's a classy, professional group of people. So people will work things out in a responsible, professional manner.
Right. I just think what you can't convey, you can't impart is, here's this many years of files on something, or if there was a question about Pfizer, we might have something going back to 1988 that's not going to be immediately on the radar screen when you're transitioning a file. And, when will that happen? Or we might remember, oh yeah, remember when we tried to make that charter change, or the town tried to make that charter change and it didn't happen, so that meant this happened and that meant that happened. Well, if there's a question on a particular charter issue, it's just not that we can turn it over and do the best we can, but I just can't say that we can share that bank of information. Just not because we wouldn't want to, but just I don't think it's really possible.
Okay.
What do you perceive to be the town attorney's role in dealing with the council? And do you give specific recommendations, or do you advise them with a series of available options and let them decide?
The first part of that, what's the town attorney's relation? We certainly serve the town council. We are there to be the legal advisor. Again, not a policy advisor, not the entity that sets a program goals or anything like that. We're there so that if the town council has a question or wants to pursue something, I can think of just relatively recently, there was discussion about whether or not to permit marijuana smoking on public property. It's not our job to say, hey, maybe that's a good idea, maybe that's not a good idea. It's our job to say, what is it that you're looking at? What do you want to achieve? And then we can tell you, this is the way you can go about it, or nope, that's actually not going to work. Of course, in those instances, and I think we probably all take this role, and I take this role even in dealing with labor and employment issues and collective bargaining when the opportunity presents itself. Yeah, there could be multiple options to something. And certainly, if we could say, I know there have been times, when John has said, well, what are a couple of ideas? What are the options? Sure, we'll put out everything that we can say to you will be legally acceptable or be able to be legally enforced. And then it's a council's decision. It's not ours. We can provide you with the options and the legal guidance as to how to get there.
If I could just add something, I've worked with a lot of legislative bodies, either town councils or other kinds of bodies. The councils, the legislative bodies usually come up with policies, and their struggle often is, how do you land the policy? How do you give it form in a legal sense? Is it an ordinance? Is it a resolution? And that's where our role comes in. Is we hear you say you want to accomplish X, Y, and Z, and it's like, how do you get there in the most legal way? And how do we do it constitutionally? And so our goal is to land that in some kind of a writing, some kind of a law. that either there was one of general applicability or is one that's more focused. Should it be an internal matter for the town, or should it be, town-wide? So giving legislative policy form is something I consider to be very important for the town attorney to represent, to be effective with a town council.
How do you go about explaining complex or difficult topics or rulings to council members who are unfamiliar with municipal law?
Well, I'll start. And everybody might have a slightly different way of dealing with that. So I can say, and I'm just going to go back to collective bargaining and labor negotiations for the moment, that yes, when a new council comes on board, many times they will be unfamiliar with what's the process? What does it mean to negotiate? Who sits there? What's our role? What's your role? What's HR's role? And in those instances, and particularly when we're heading into a season where there might be 2 or 3 negotiations coming up, we found it helpful to sit down at the beginning of that point in time, the beginning of that season, to go to the council. And we can have that meeting either as a non-meeting or an executive session to meet with the council members to talk about strategy related to collective bargaining. And that, in that instance, that also gives us the opportunity to educate as well and to explain these are the steps that are being taken, these are the roles you have. One of the things ultimately with collective bargaining is that the legislative body, the town council in this instance, has to ratify or not ratify the contract. So my philosophy, and I think Christy's philosophy as well, or our philosophy, is that we don't want surprises either. So we want to be sure that our council members actually understand the collective bargaining process, and they work with us to outline what the financial goals in particular are related to wages and health insurance, because we don't want to come back to you at the end of a negotiation process and have the council say, no, we're not going to ratify that, because that sets off a whole other host of issues which we would be explaining as well. But I think just using that example, I know you said a complex issue, but I would consider that to be something that, there's not really a reason why new folks would really know about that, and it's important to take the time, I think, to go ahead and explain that. Eric, do you want to jump in, or Rich jump in on that to talk about another issue?
I think you made a good point. Part of one of the big challenges that town's attorneys have, and in order to be effective as town's attorneys, they have to be able to explain complicated legal principles to people who are not familiar with them, and are trying to accomplish things legislatively by being elected volunteers. And the law sometimes can be very obtuse. It can be very subtle. Sometimes it doesn't make sense, and the job of the town attorney is to make sense out of it for the legislative bodies and the staff in particular. And so you can measure that, the success of that, by how long a person remains a town attorney. They're either effective or they're not in explaining matters. And, I think here, Sussman Shapiro's got a lot of experience, a lot of very, very effective advocacy and explanations for, with their municipalities. But it is a challenge at all times. And I think the attorney's got to take the time, the care, and the attention, either in writing or orally, to express those principles in simple ways that can be understood and appreciated, so that you can make a sound decision.
All right, thank you.
What is your experience and expertise in reviewing or preparing contract documents for construction projects and services using either local, state, or federal funds?
I want to use the word enormous, but I don't. I've spent all the years doing municipal law, doing construction agreements for, whether the funds are coming from grants, federal grants, state grants. I've worked with the AIA documents quite a bit. I draft my own documents, whether they're bidding documents, construction, design, build, bid. So, whether they're 300 pages simple agreements, for something more simple. Done quite a bit of it for school projects, sewer treatment plants, roads. We've done a lot of real estate transaction work too, in terms of if it's leasing. One of the things I've been doing a lot of is solar leases, solar acquisitions, and those sorts of agreements, and tax abatement agreements lately. So I probably do not, but I do not only. And I know Eric, I work very closely with Eric on these. We're not only just drafting the agreements, but also once they're in place, working with either the general contractor or the design contractor or the some manager, helping implement the contract and avoiding pitfalls as you go along, depending on, and helping decide whether you've reached substantial completion or there's completion. And then, of course, hopefully everything goes happily and you release the retainage and the project's over without litigation. So,
Eric,
I don't know
did
if
you want to add anything?
Sure. I think it's also important to keep in mind when you're negotiating construction contracts the significant amount of leverage that the town of Groton and other municipalities have, and making sure that those contracts have the revisions that benefit the owner incorporated into them before you put them out to bid. And like Rich, I have experience with not only negotiating contracts and understanding what the language means, so that if there is an interpretation issue or a dispute as the project goes along, being able to sit down with the contractor or the designer and their respective attorney and trying to resolve the dispute, which we've had a lot of success doing on behalf of municipalities, but also, understandably, sometimes disputes can't be resolved, and we have a tremendous lot of experience mediating, arbitrating, and litigating those disputes with success to try to put the owner in the best position possible and in the most cost-efficient way that can be done.
Okay, thank you. What is your experience in performing research in matters of municipal land and right-of-way ownership determination?
You want to start?
We've had a significant amount of experience in land title types of issues. I know that Eileen and I worked with the Attorney General's office to remove restrictions that were involved in one of the town-owned properties to allow it to build a school. We've got a team of resources who have research titles back to the Civil War era to understand rights into property and whether there are rights to use it.
Sometimes there's always municipal issues with respect to rights of ways, like for instance, sewer easements. A lot of times you'll find that the sewer line is not in the sewer easement after doing some surveys, and you have to fix it. So that requires land title research and then maybe working with the mortgagees to get subordination agreements. So I'm actually working on a considerable project in another town where they're trying to line up the easements with the actual location of the pipes. And you run into the same thing. It's pretty much the same thing with roadways. Unless you're abandoning a roadway, then there's a procedure for discontinuing public rights of ways. But it's ordinarily it's you resolve them by dealing with the property owners, acquiring drainage easements. Sometimes you have to litigate with a quiet title action or claim adverse possession. Some people will claim that the street is not actually where it is, and then they'll say that's my land, and so you may have to bring a quiet title action. But I'm very familiar. We're very familiar with the statutes that govern public rights-of-ways, sewer easements, and streets.
Thank you.
Please describe your level of knowledge in the appraisal of commercial property, in particular in consideration of the income approach to value.
Well, as I indicated earlier, I've been involved in land valuation cases for tax appeals, or land valuation case, whether it's a tax appeal, whether it's a condemnation matter, or some other matter, since the early 90s, and handled and litigated a case to the Supreme Court 2 times, the valuation of the Wyndham Mills thread complex. It was heavily contaminated, and the first case established the fact that a court could reduce market value by the cost of the environmental contamination and cleanup costs. The Supreme Court struggled for a year and a half on that decision. We prevailed, and then it went up a second time on the valuation, where the question there was whether a grant that was available could be added into the value, and the municipality would have to pay it. So the approach to value there was comparable but also unique. In a lot of tax appeals, as you know, if it's commercial property, you're usually dealing with the income approach, backed up by a comparable approach. If not everybody understands appraisal work, there are generally 3 approaches by which an appraiser achieves an opinion of market value of real estate. It's a comparable approach is the most common because it's used from residential properties. The appraiser goes around and finds similar properties and finds out what they sold for, averages them out, and says this is what this property is going to be worth. The income approach is one used mostly for commercial property that's not unique property. And so you take the income, you calculate it against a cap value, and you come out with a value. But you back that up, the appraiser will usually back that up with a comparable value. Where if it's a unique property, like the Pfizer campus, the income approach doesn't work because there's no income. It's used by a single source. You can't really find a comparable sale of a Pfizer campus, so the approach is then the cost value. And that's the one that's probably going to be used in the upcoming trial. But I've been doing that since the early 90s for a variety of towns. And I usually handle about 10 to 15 cases a year on commercial tax appeals. And I'll just defer to Eric.
I couldn't say any better. We also have a great resource of appraisers who understand the cost approach and help resolve tax appeals efficiently for the municipalities that we represent.
I should add too that not just the valuation issues when it comes to assessing, but also the exemptions. Whether the property is taxable or not, or is it exempt under 12-81? And we've worked, over the years with different kinds of claims that this property is exempt from taxation completely. And sometimes you have that sort of a challenge, like your fuel cell case.
Thank you. Please describe your knowledge of handling tax appeals for commercial and residential waterfront properties. As you know, Groton is like a big peninsula bounded by 3 sides of water.
Well, the problem with waterfront properties is exactly the fact that everybody wants waterfront properties, so nobody sells them. And it's hard in order to get a waterfront property land sale, it's hard to find it. So, as you know, we've worked quite a bit with, I've done several tax appeals or challenges to values of property along the Thames River and up into Stonington. I run into it sometimes on the sewer commission too, as we're assessing benefits. Because an assessment of a benefit for sewer purposes is the difference in value between what the property would be worth with sewer versus what it is without sewer. So you have to get two appraisals, so to speak. And so, the problem is what's selling and where the market is. And with waterfront, a lot of it depends on where it is. Like you can be on Mason's Island and there's one marketplace. You can be in the borough of Stonington, only a couple miles away as the crow flies, but they're two entirely different marketplaces. But generally with waterfront property, one of the problems is finding a land sale if you're going to do a cost approach, because there's just no land on the waterfront that sells. I don't know if Eric wants to add something.
I think you also have to look at linear footage of waterfront views. I've found with waterfront properties that it's the type of view, whether you're looking at a river, you're looking at a sound, can make a significant difference in the value of the property or how the taxpayer views the property. I have found in many tax appeals that if you can look up the assessment to sales ratio and be able to convince a judge that the assessments are pretty spot on with the sales that have happened, and oftentimes they're slightly less than those sales, that is very telling and valuable information in getting a judge to resolve a dispute in favor of the municipality with waterfront property.
And one of the difficulties in dealing with waterfront property is finding a good appraiser who's familiar with it and can value the riparian rights, the rights to the dockage rights and the usufructuary rights, as they're called. And sometimes the challenge in dealing with that is just finding the right appraiser, finding someone who's qualified for that, as you probably know.
Thank you.
The other challenge with waterfront properties is, while most of the time we look to find ways of resolving things without having to use the court system, because of the limitations of a mass appraisal on waterfront properties in particular, and whether you can adjust accurately enough, it's more likely to be a situation where the best advice to the town is to use the court system to mediate the dispute between the town and the property owner, because that's the only way that you're going to protect the town's position. Normally we don't urge folks to go to court, but sometimes you have to take a harder line when the amount of value they're talking about with waterfront properties.
Thank you.
Sorry, I didn't mean to take you.
If you were our town attorney and assigned to an investigation, what is the process or steps you would use for conducting that investigation, and would this differ depending on the type of investigation?
Do you want to start, Christy? Sure, I'll start. So it does depend on the type of investigation, but initially the first step is obviously to meet with you and whatever perhaps managerial staff needs the investigation conducted. It also depends on, us gathering initial information about what the type of investigation, whether it's a discrimination complaint or a workplace violence complaint. It depends. It really depends on the type of the nature, whether it's a misconduct for some kind of workplace violation outside of that type of policy. So it also depends on whether you're dealing with an investigation of unionized staff versus non-unionized staff, because the initial scope of the investigation would need to take into account whether there are representation rights that need to be protected, and typically the first step is determining whether or not it's necessary in the scope of the investigation to have any employees removed from the workplace while the investigation is happening or not, whether their presence in the workplace is going to taint the investigation, or whether there's a serious enough concern that they should not be in the workplace for other reasons. So you make that determination, and then generally you need to make a determination as to who's actually going to conduct the investigation, and that depends on the type of situation at hand, whether it's going to be HR that conducts the investigation, whether it's going to be our office that conducts the investigation, or whether it's going to be an independent third party that conducts the investigation. That all needs to be sorted out right from the get-go. And then the process starts. If, for example, it was going to be our office that conducts the investigation, we typically would review any initial materials that you have, any emails, a written complaint, and so on and so forth, to get an understanding of what the situation is. My first step would be to meet with the complainant or the person making the allegation to really understand. A lot of times complaints come in they're either in an email or somebody's handwritten notes from a phone call, and so you have to go back to the complainant and actually go through and question, get a clear understanding of what the issue is, determine whether there are any witnesses to the situation, determine who those witnesses are, whether they are witnesses that could be subject ultimately to some kind of disciplinary action, which warrants notification of investigatory interviews and their Weingarten rights to have a union representative present while they are interviewed. I personally like to record interviews for note-taking purposes, and if that's amenable, if the parties are amenable to that, it just helps get the flow of the conversation in order to have a good understanding of what's being said. Sometimes it's harder for me to write when I'm talking with an interviewee. It's also a good idea to have somebody else present when you're interviewing. If I was not the one conducting the interview and somebody here was conducting the interview, perhaps having two people there for somebody to take notes and also a second witness to hear what's happening. And then generally speaking, you loop back with the witnesses. You ask if they have anything else to add, and you pull it all together, determining whether or not there would be a written investigation report really depends on what the situation is, what the findings might be, and certainly what your preference is. I've had cases investigations where, after sifting through the evidence or the information, there wasn't a whole lot there. There wasn't a need for a real lengthy written report, just some simple communication back that says, this is what I found, it's unsubstantiated, or people weren't cooperative, whatever the situation might be. And then I've had investigations where the client has asked for a full written report with a legal opinion in it. So, we've run the gamut. Eileen's conducted a number of investigations. I've conducted a number of investigations. We've assisted HR departments or department heads in some smaller municipalities to determine if they want to conduct the investigation themselves. We've kind of assisted them through the process. But really, it's about understanding what the scope of the issue is, what policies might be implicated, and certainly protecting the rights of employees who are unionized, to make sure that you haven't run afoul of any bargaining rights that they have with representation during the process.
Yeah, maybe the only other thing I'd add, I agree with everything Christy said. Sometimes at the outset of investigations, too, when you're sizing up what the issue is, if the issue potentially could also involve criminal misconduct, you have to take other certain steps at the outset to sort of separate out the investigations you'll have, and you have to look at what types of rights the individuals will have for you to be able to compel them to answer your questions, et cetera. So, other than that, it's...
Yeah, and I think following on to that, when our office in advising and assisting municipal clients when those types of issues come up, our services that we're able to provide is, preventative, proactive counseling through it, assisting in drafting the requisite notifications and documents that you need, not just conducting the investigation, but assisting, and then once you've made the findings, once the investigation is concluded, determining what steps the town can take to address address this situation, one of the things that I always ask is, and it goes to one of the questions that was asked previously, I think by you, like, are you going to offer options or what? Well, the questions typically are, okay, we have this information. What do you want to do? And that's my question to the client. Well, what do you want to do? And then my job is to tell you what you can do and what you must do with the information from a legal standpoint, and then help you prepare whatever documentation is necessary to get it through the final, because typically with investigations, if there is something that's substantiated, it could trigger a whole slew of other issues with the grievance process. If disciplinary action is taken, you want to make sure that you have a nice package of documentation at the end of the day to be able to rely on.
Thank you.
All right, we are getting close to the end of our time. I don't know if there's any other critical questions that people have. If I could always skip one, or I can keep going.
Is that one? No, I think you answered it. This kind of goes to what you were just saying, but especially being new counselor, so this will be a question that helps us. Experience on providing training, municipal, to municipalities on public records, public meetings, and specifically Freedom of Information Act. So what do you do to help?
Sure, that I can jump in on. Many of us can jump in on this. Yeah, we're always happy, prepared to provide FOIA reviews. We also often say Tom Hennick is a wonderful resource too, and we know that. So, and we respect what he does. But we're always happy to jump in, whether it's to specific commissions or bodies. We've done that with land use bodies in the past, or to the council. A couple of years ago, we did some training actually on town charter provisions and what the sort of council's role is in relation to the town charter. We certainly do harassment training or anti-harassment training when that comes up. We've provided trainings on reasonable suspicion and testing and things like that. It pretty much, if there's an issue or a need, we're certainly happy to jump in and do that, because I think, as many folks have mentioned today, you're better off with the information. We're better off with you having the information, because that's going to help us, to guide you better. So we're certainly all for.
Do you initiate the training if you see a lack of skills on certain areas, or is it something that the town sort of?
It's typically been something that the town's approached us on. There has. Some years ago, there were some issues with the abilities of members on land use boards to be able to sort of really get along. And we did some, I'm not sure exactly how that one bubbled up, but we wound up doing just some general kind of civility type training for boards and commissions where we went to. But I'm sure, if we saw something that was really of concern, I know, like I would say to John, is this a problem? What's going on? But otherwise, I think that's one if people have a desire for us to do. And we'll do presentations for other groups too.
Plus, we find that it's sometimes a good idea, because of the number of people, the turnover in various boards and commissions, that you think people, the commission, the board knows it, but you get significant turnover, and it helps to have a refresher course. The other challenge about FOI and meetings in particular is, social media has created lots of complications in life, but you get people communicating with one another, during the meeting, and they're basically conducting, in some circumstances, and they're just naive. They don't realize how, the public's business is supposed to be conducted in a manner that everybody can hear what board members, commission members, and what they're saying to one another. So technology has created new challenges that people have to be aware of how strict, government in the sunshine rules are.
Thank you. And we have now reached the end of our 90 minutes. I appreciate everyone's attendance and information. And
Yeah, just briefly, if I could. Again, I think as you've heard from most of us here, we like what we do. We like municipal work, we like public sector work, and we really liked our work with the town of Groton, and we're proud of the fact that we've worked with the town of Groton all these years, and we really feel that we can continue forward in a positive manner and a great partnership with the town. So again, respectfully, we'd request that you recommend us for reappointment.
thank you.
Thanks.
Thank you.
Thank you.
Thank you. Thank you.